Well, good morning, everyone. We welcome you to this 16th webinar of EEE Series 2.0 series, which is Enable, Evaluate and Excel, a bi-weekly webinar series on Companies Act and SEBI laws. And in view of various amendments, the ICSI has relaunched EEE 2.0 webinar series on Companies Act and SEBI laws as an attempt to keep the governance professionals, its members and students abreast with the changing dynamics of these laws. The webinar series is being held bi-weekly on every Tuesday 11 a.m. to 1 p.m. and every Friday at 3 p.m. to 5 p.m. Now, in this 16th webinar, which is on the topic of issue of securities covering IPOs and FPOs, and in today's webinar, we have a very learned personality with us, Mr. B. Ranganathan, fellow member of the Institute of Company Secretaries of India. He is currently General Counsel of MCure Pharmaceutical Limited. Mr. B. Ranganathan is presently with MCure Pharmaceutical Limited, and prior to his stint, he has been with Edelweiss Financial Services and with Tata Group. He had a long stint with these reputed organizations. And apart from being a fellow member of the Institute, he is a fellow member of the Institute of Post and Management Accountants and holds a degree in law as well. He has over 3 decades of experience in corporate field, encompassing corporate governance, company law, investment banking, corporate restructuring, NBFCs, and allied corporate laws matters. And also, he is a very distinguished member of the Secretarial Standard Board of the Institute of Company Secretaries of India, and he has been member of Company Law Review Committee constituted by the Ministry of Corporate Affairs to review the Companies Act 2013. He is senior faculty with various business schools and regular speaker in ICSI, ICAI and ICMA, besides being attached to various industry bodies. He is a regular faculty with the Institute of Directors as well. So we welcome you, Mr. Ranganathan, to this 16th webinar, and we look forward to your deliberations on the listing of IPOs on main board and follow-on public offerings, of course. And in between, we will be having questions from participants, audience, which is joining from all over India. So we will be trying to take up questions also which we received during the course of the webinar. So we will be throwing it to you as and when we have a space and we have a chance to raise questions. So we would first request you to address the participants on the recent developments. We have seen recently there have been notification issued by SEBI on LODR Third Amendment regulations also as latest as 13th August 2021. So we would request you to first address the participants on the theme of today's webinar, and thereafter we will be having a question answers round from the audience. Yeah. Over to you, Mr. Ranganathan.
Yeah. Good morning, friends, and good morning, Mr. Mehta. And it's really a privilege to be among the professionals and addressing you all. And thanks to the Institute again for inviting me to deliver, whatever my thoughts on the IPO listing. I think it's a good initiative that the Institute has started in conducting such kind of webinars, irrespective of whether it's a weekday or a weekend, and only depends on how we are prepared and what is the level of interest that we have in each of the topics that are being organized by the Institute. I think it's a great initiative. Thanks to Institute, we should acknowledge that fact, and it's for us to take advantage of this, friends. So with that note, what I'm going to mostly cover today is, we have been seeing spate of companies coming out with the IPO even within 4 months. You file a document with SEBI in April, and we had seen the company that had come out in July end with a great hit, So those kind of things are happening. Always there is a saying in financial services circle, the capital markets has a 7-year life cycle. How every business has a life cycle, even the capital markets as a life cycle is what we know. And in fact, what is happening in every time, something happens, the 7-year horizon, if you see, go back to 13 and 14, how the markets were booming in those days, a lot of issues. So similarly, the same kind of things are happening in the present world. But yes, having said that, that's from a business opportunity point of view, and how the corporates use the IPO route to raise funds from the public. That's one of the things. But what are the precautions and what are the great opportunities that are available for all of us is what, broadly I and Mr. Mehta will be talking today on that. We'll deliberate on that and see how best, as professionals, that how best we should also, use this opportunity to, to excel in the professional life is what I would believe. And let me again start with a very good, one note which I always emphasize, and not only in my team meetings, but also in any forum, is that please, friends, have confidence and very proudly to say that we are the best professionals to interpret corporate laws. I think we should have that confidence within us. I think we have got so many. Hello? Am I audible? Mr. Mehta?
Yeah, you are audible, sir. Please carry on, sir.
Okay. Yeah. So, we are the best guys. Have confidence. I think the mother of all corporate laws is Companies Act. We should not be, think that, we should be focusing only on the company law aspects or the filing of forms and other things. Please, we also have a great opportunity, and we also know how other fraternities have taken over this space. So I think with that note, let me get into the topic and let's discuss. Mr. Mehta, I will come back on the latest amendment slightly during the course of my discussion. We will discuss that also. Of course, it's a very crucial thing that had happened on the 13th ICDR on the 13th of August. So let me start as always, friends, when you talk about any kind of capital market or any kind of a new legislation that are being, you need to see the background to that. So very quickly, let me take you through the history of capital markets and why we are talking about this in a very quick, in a Sevag manner. Let me just take you through, and come 1956, when we had this Companies Act, overall the Companies Act of 1930, and which became 1956. Simultaneously, a need was felt to have a separate set of regulations for the securities market, and that's why we had the SERR and the SERR rules. SERE and the SERR rules in 1956 and 57. Why I'm emphasizing is, when you talk about securities market and when you talk about the IPO thing, apart from the Companies Act, SERR is also a very important thing that needs to be done. And 50s and 60s. 60s was more of companies in more than going for fundraising activity, though there were a very few. It was more of conglomerate mergers that was witnessed during the time of 1960s. So more of combinations that happened in 1960s. That's why we have the MRTP Act that came in 1969. But come 70s and 80s are crucial from an Indian perspective. Now 70s, a very beautiful thing happened. We know that Reliance was incorporated in 73, 74, but post that, we know how the capital markets have risen, and 70s, there was a very good thing that had happened, and we had George Fernandez as the industries minister at that point in time. He came out with a very innovative idea, saying that all the foreign MNCs that have established shops in India in the form of a wholly owned subsidiary, or should first they should divest 40 to 51%. There were some two categories of things that were there, and it was very clearly said that those people, for foreigners who are in India, should offload their shares, and they can retain only not more than 51% or not more than 40%. That was the condition that this minister laid down. So a lot of MNCs had to offload these shares to the entire public, and that's where the concept of, again, going back to the public, and what do? Go to the public and also get that listed. That concept came thanks to that, and the capital market slowly started picking up for and some MNCs left the shores. For example, IBM left the shores. There were other people, but today, if you talk about one of the best company that we all have and we should be proud is the Hindustan Levers. Unilever also could have gone back, but I think they are staying back, and today we know how they are contributing. So, there are always pros and cons in all the events. But 70s, so it started kickstarting, and slowly, the securities market started, people started knowing what is this capital market. Then come 80s. I think 80s belongs to only one person, the late Dhirubhai. I think the entire metamorphosis that happened during that period of 80s, I think thanks to only one man, late Dhirubhai Ambani, I think we all owe that credit. He was the guy who, inculcated the equity cult in all of us and in India. So, and what kind of issues Reliance came and what kind of instruments that we are talking about today, all those things were, very easily done, and, the risk-taking ability, we all know how. And that was the background to this entire chain of things, and 80s and late 80s. All these things, the entire process were, driven only by, if you ask me, it was only more of Companies Act, predominantly Companies Act and Schedule 2 of the Companies Act, which was a very, say Section 56 to, of course, 55A came much later, 56 to 60, 61 and 64. I would also call 64 to that extent. And the Schedule 2 was more importance or emphasized, and that was the background to this. But at the same time, there was this guy sitting in Delhi and controlling this entire process in a manner that ultimately the pricing was fixed by a guy called the Controller of Capital Issues. Control of capital issues, and whatever the entrepreneur wants to go to the public, but the price is determined by somebody else. But yes, having said that, because today when we talk about the SEBI preamble where investor protection, I think there were indirectly it was already being taken care of but at the same time when I look at the promoters, if I could have garnered more money from the public, I was told that please go stepwise, stage-wise, or go slow. So in terms of the pricing that was fixed. But friends, let me tell you, CCA formula is one of the very good formulas that all the valuation experts normally use. Now, of course, many people don't use, but going back, I would suggest that all the registered valuers among our fraternity who are taken up should also look into the CCA formula whenever you are arriving at valuation of shares as a background check as to whether the way, because it's a very conservative way of arriving at the share price. So come 88, the Minister of Finance had a division called, have separately carved out for this, and come 1992, we had the SEBI Act in place sometime in April. Before that, it came as an ordinance in January, and that is where the entire thing started. And today we are talking about SEBI Act, which is almost 30 years now today. And even SEBI Act had gone different miles, and today, how the innovations took place in the financial market with a lot of instruments coming in. But in terms of the opportunities that are available for us, I'm talking right from those days, like 92 when it came, till 2000, it was all the entire public issue was more of, circulars, which, if I remember, there were some 21 or 22 circulars that SEBI came out, and it was all driven only by those circulars. But one of the good things that SEBI did was, from a controlled regime, it became a free pricing mechanism after SEBI came into being. And, so the entrepreneurs were allowed to fix the price as they wanted, and we know how the market reacted immediately. All the entrepreneurs, most of them, and today, we know about the fly-by-night operators. Come to 1992 to 1995, 96, lot of hell broke in the stock market, and lot of issuers, fly-by-night operators, even without having a registered office, they all vanished. So 95, 96. again, it was all subject to a lot of, there were a lot of scams that had come. And between 96 and 98, 99, again, there was a lull in the capital markets, because in between you had the CRB scam on the fixed deposits. And 1998, 98, I think, friends, we all know a major amendment to the Companies Act came in the form of 372A and 370, etc. But apart from that, there was one more provision which really mattered the most. Today, when we talk about buyback of shares, I think though it had come on as a part of 31st August 1998, it came as it was gazetted only in January 1999. But buyback, again, the government thought it will revive the capital markets, but it did not, because at that point in time you had only one or two buybacks, but slowly, you had a lot of other buybacks. So a need was felt, and come 2000, you had this circulars which SEBI was issuing for regulating the public issue, became in the form of guidelines, disclosure of investor protection, DIP guidelines, which came, and and people started, and the corporate started following the DIP guidelines. And next, more importantly, one of the major things that the DIP guidelines contained was the manner in which the pricing of the price should be fixed. So one of the good things that came into being was the book building exercise. A lot of companies, and Maruti Suzuki is one very classic example in 2002-03, when it garnered a huge amount of money, and the book building exercise was tested amongst some 10 companies. Maruti was one of the good hits during those days. And so book building, so from what people were used to have a pricing mechanism, it was more of a book building driven process that was tested. So book building, straight away, let me take, friends, is book building is nothing but, you are giving an opportunity to the issuer to fix a price band within a particular band. Now that band cannot be more than 20% of the upper and the lower. For example, 100 to 120 could be the maximum limit. That the reason for giving is you allow the market or the investors to determine the price at which, the real price at which the issue could be opened and the issue could be made. And that was the reason that this book building as a concept was introduced, which is a good concept, which is followed in some other jurisdictions, which is called the Dutch auction method of, But today, when you talk about this, it's a great thing that is being given to an entrepreneur, a price band. But at the same time, going back, when you go back to 2002 and off late, you don't see the issuers fixing such a big range, And so now you have, say, for example, 800 to 801 or 800 to 805 or 100 to 102. That's not the correct range. That means you already know that this is a price. But this Dutch auction method is a very good concept which many jurisdictions follow, especially for, at the time of what you call as a delisting, or even for when there are bids, auctions when are made for acquiring companies. But somehow or other, today in Indian context, this is not really doing the real value addition that this kind of a pricing methodology should give. And that's why now even SEBI is thinking of, and it's floated, I believe, a discussion paper on why book building, is it really required, or should we resort to the fixed price mechanism, which is already in vogue. Because it does not seem the way it should have been done, is one of the things that SEBI is also very deeply considering. So, but it's a good thing, but I don't know, Indian corporates have not utilized to the maximum advantage. So that's a book building. Book building is nothing but the price within the band, the price at which the maximum number of shares are tendered will become the ultimate price for the proposed public issue that we have to. Fine. That's on the book building. Now, going back, a lot of things happened in the SEBI, SEBI regulations, SEBI guidelines. It was a guideline, then became a as a regulation. If I remember correctly, it was on 26th of August 2009 that it became in the way of a regulations, and it's been taken. And today we have the 2018 regulation, and now got amended from time to time. So what are the different things that we need to now, as a company that wants to go in for a public issue, and as as a CS fraternity, when we have a greater role to play, both friends from a employment perspective, as well as if you are on the practicing side, there are n number of opportunities for us, not only to commercially, but also to learn many things is what I would feel. So there is a great opportunity lying, whether it's in the main board or in the SME sector. Maybe the process is slightly different, but at the same time, as professionals, you and I can contribute a lot to this space. So how do we do it, and what are the different things? So, I have a PPT. I will just share a few things, but I will more talk on more extempore rather than, because please friends, so whoever is doing an IPO or intend to do IPO, you might chart down certain things. But what I would first feel is, in any IPO, if you are attached to a company, either in the form of practice, when I say please, let's not distinguish between employed and a PCS. It's all same, right? Okay. Now, please advise your client, or let's advise the management.
Voice is not audible, sir.
Not audible?
Now it's okay, sir.
It's okay, right? Till now?
Yeah, now it's okay, sir. Please carry on, sir.
Okay. Maybe, okay. So you need to have that, kick-starting the process. What I'm saying is, first and foremost is, friends, what are the 2-3 major acts that you and I should be cleared? We should be clearly knowing. One is the Companies Act, of course, Companies Act. Second one is the ICDR. Third one is the SCRR. I think these are the primary regulations that you and I should be knowing it. In addition to, if you are sectoral, if you are attached to any sector, you also be aware of certain sectoral things. 1 second, please. Apologies, some disturbance. Yeah. Okay. So 3 main acts is what I would believe. So let me just quickly take you through a small, a big exhaustive, but I will stop somewhere and hope this is Mehta.
Yeah, now it is fine, sir.
It's fine, right?
Yeah, perfect, sir.
Perfect. Take it. So journey we had seen the journey. So it's not from a control pricing. This also we covered. Now let's understand when we talk about this 3 acts. What are the first of all, let's understand certain terminologies which people normally use. One is on the primary market and the secondary market. Capital market, we all know. Primary market, you understand the raising of funds, and the secondary market is in existence, right? So as far as the primary market, again in the form of the primary market, what are the different sections that you know? Before I get into this, let me. Now, friends, we all might be knowing that it's only the SEBI Act governing the process of enter ICDR, and they are administering, no doubt in it. The power to SEBI comes from Section 24 of the Companies Act, friends. So it emanates from the Companies Act, okay, in 24, and earlier it was 55A, which came in 2000. So the power to SEBI comes from Section 24. And then the SEBI Act takes over in the form of regulations and everything. That's one thing which you and I should be knowing. I talked about mostly on the minimum public shareholding limit that one has to have it. Okay. Now Now, Section 24, when you talk about Section 24, it also talks about the companies whose shares are listed, whose securities are listed, but also it also talks about a company that intend to get listed. So when you say intend to get listed, friends, there is a what do you call, the intention of the company by virtue of its various acts. It is deemed to be a company that wants to go to the public and get it listed. So I am saying this is very intent to get listed is one of the major trigger that happens the day you file DRHP is the applicability of PIT regulations. So vigorous as it happens in a listed space, at least you should start building that the regular framework of making an awareness among the management and your colleagues about the implementation of the PIT regulation. So right from day one, when you file the DRHP, the SDD maintaining date forms kickstarts, friends. So let us be conscious of that fact. So straight away, let me also tell you one more thing. We all have this in mind that only when a company gets listed, we need to follow DR. But one of the requirements is the company should be compliant with most of the provisions of LODR, especially the constituent board and its committees is what the regulators expect. So friends, before you file DRHP, please ensure that the board and the are aligned not only with the Companies Act, but also with the LODR requirements. That is one thing. Now, let me just cut and get the shares listed. One is fundraising by the company, which the company issues fresh shares, you get the money and the paid up capital increases, which is the typical attributes of a primary issue. But there is also another thing that's called an offer for sale. What happens is when the existing shareholders wants to get away, wants an exit route. For example, today if you see the 15 years or so, a lot of companies, before they launch a public issue, you have a private equity player coming and investing in the company, maybe for more than 2 years, I think 5-6 years, whatever, depending on the company. Be in a better shape than because of the lot of governance that this private equity guys bring on the table of IPO at the correct stage. So that's one thing. So they kickstart at the maybe 3-4 years pile. But as company secretaries, what are the different things now? Real friends, first and foremost, I would believe, more than getting into things, please friends, my earnest request, people who are who has to see the constitutional doc quite often, but we are the people who do not see, in fact. So please, friend, the memorandum, please look into your articles of association is one of the thing that you need to do upfront, saying that what are the okay, if there is a private equity guy or if there is a shareholder who has already come into this, is there a shareholder agreement, provisions of shareholders agreement that has gone into these articles, those restrictive provisions, which you should remember that listing all these rights of the shareholder, the investor share will get completely knocked off. The only thing he might have is to have a nominee on the board. That to post listing, he has to take the shareholders' approval. So please, articles are in correct shape with all the provisions, because once you get listed, amending the articles with so many things becomes a difficult task. It's easy in a difficult task in the sense you will be watched, right? You will be watched. You need to be careful of so many things. One of the small thing, let me tell you, friends, which most of us would not have noticed is a preferential offer, irrespective of listed or unlisted, a preferential offer when you want to make under 62(1)(c). Articles should very specifically mention this 62(1)(c). This is one thing, please be mindful of this whenever you want to, you are wanting to change the of association. This is first and foremost thing that you need to move. Second thing, Mr. Mehta, I'll just come back. I'll take a break after 5 because I just wanted to emphasize this first, and then maybe we can chat. We can chat and we can deliberate. Okay. So the important aspect, friends, is please get into the corporate records. What I'm saying is your company might be, am I audible, Mr. Mehta?
Yeah, you are audible. I think at this stage, if you could just dwell upon like what important role a company secretary can play here at this stage when you prepare for an IPO. That is, I think, one of the very critical stages of this entire IPO process, where a CS has to play a very integral part and very important role.
Okay, that's what I started with. Being a CS, whether you on both the sides, start with have to concentrate is the secretarial records. Now, when I mean the secretarial records, friends, especially for those companies which are very old companies, or say maybe 2025, or maybe even much more than that, you may not have so many records because all the electronic records could be available on February 2006. But prior to that, you may have to do whatever it's best to your ability. You need to find out, because I'll tell you, maintain some form, some record or otherwise. It's not that a company functions without keeping records. But that is where, Mr. Mehta and friend, I think that's where our role comes. It's a great opportunity for a practicing CS as well, I'm saying. Like, nowadays, so prefer. In fact, realize the importance of us, and they are entrusting this entire task of doing a diligence on the corporate secretarial records to us. It's a great opportunity which we all have to sit with. So first is secretarial records. What I'm saying is, friend, don't stick to, for example, first minutes. You might say, minutes and all, you don't get more than 15 minutes back. You will get it. Handwritten minutes hoga, kidhar na kidhar, you should find out how the minutes have been made. Coming into what is the ultimate impact of all these things if you don't. So the forms, for example, one very thing which I was facing was that we did not get some kind of a share transfer forms of some promoters. But you have all other records, board minutes, the price at which was the bank statement, the ledger, everything, but you don't have the form. So again, similarly, in case of allotment, you don't have particular form. On this is, I think as a CS, we have to concentrate on this and upfront, if possible, try to get all these things. And you should also use your, to convince, if the form, for example, if form 2s are not available, what are the other records? Go to resolutions, go to register of members, go to annual returns. Please convince them, kidhar na kidhar you will get. Okay, if the company, sometimes it happens that you don't have mentioned the price. Unlike these days, those days nobody used to mention the price of at which share is being issued. They all would have been issued only at a face value. The financials and see at what stage the company had issued premium. So these are the ways in which you could garner the just because a form is not available, it doesn't mean that the company is not maintained. But it is for us to put everything in a plate and give it to the diligence guy, to give it to the merchant bankers to see this. Please, boss, dekh lo, ye cheez hai. So that is how you win it. That is where Mr. Mehta role comes in, and it becomes a greater role for us. Don't stick only form 9 mil raha karke. You should actually know where are all the impact happens, and that is where I think you and I have to be extra cautious doing it. So this is the first thing I just wanted to touch upon, Mr. Mehta. Again, now let's converse for some time and then again go back to some other crucial things.
Very aptly covered, sir. I think you covered in greater detail. I think for our members, it is more important to know like how the company has evolved over a period of time. What significant corporate events have taken place, be it, change of registered office, be it change in directors, change in auditors, everything has to be, seen by the company secretary, because he will be then asked all these things by the merchant bankers in one point or other point in time.
Correct.
So he need to, get acquainted with all kind of, historical information of the company, not only confining to statutory books, registers and records, but also, knowing about the businesses of the company, branches of the companies, if it is operating from different other locations. So all those things he need to get acquainted with.
Okay.
Because he would be, invariably there in all the meetings which takes place, be it merchant bankers or the legal advisors or other agencies which are involved. So he has to be the single point of an interface with all these intermediaries.
Correct. It's what you call as the milestones, which the company has gone from step by step, So when I talk about minutes, please don't restrict it to what that has been filed. You go back and see what are the different events that have taken place. And just to emanate from that, when you talk about, it's the question of identifying the real promoters. Second thing is also the promoter group. Third thing is group companies. There are three different things, friends. A promoter, go to the Definition of Companies Act as well as ICDR, how it matches, and then go to the promoter group, which is defined in ICDR. And third comes a unique thing called a group companies, which don't have in the Companies Act. Now, the group companies could be restricted only for the purpose of ICDR. And this is where our challenge comes. And this is where we have to play, don't think this is somebody merchant banker ka role hai. So if you are on the merchant banker and if you are CS, I think you got greater advantage or greater edge. So identification of these three essential things is very, very important. Secondly, the approvals, regulate approvals and the licenses that are required. Yes, please.
Right. So I think this information of at least 5 years has to be put in place. Minimum 5 years, I suppose.
Yes, minimum 5 years. But I would always urge, because what happens is you right from till date, the milestones are very important, both from a business view as well as from a saying that the company has been in operation and doing business, in a good stand. That is the reason that more than 5 years is what is essential. But yes, you need to go back and see right from inception. So milestones are also very important, friends. So even today, when you are minuting, certainly if an event happens in the company, please try to minute. At least some paragraph, a couple of lines on that would be a great advantage, because tomorrow when you come out with an FPO or a rights issue, all these things will be of a great help to us. Thirdly is that regulatory approvals and licenses. Now, don't think that it is somebody else's team that maybe within the company, some other team might be doing it, but it is for us to have upper hand and to take hold of this, saying that whether all the approvals are in place at the right time. Because why I'm telling this is even post listing, we have to place what you call as a compliance certificate before the board. Now, this will ensure and this will give a lot of greater comfort to all of us, and to give it greater to the management, saying that if you are complied with all these things, I know it is very easy to. So it's a huge task, friends, especially, when whichever industry, start at the beginning. Regulatory approvals, is another important. Yes, Mr. Mehta.
Sir, I think you touched upon very important point of promoters and promoter group. Yes. And group companies. I think this is very important, and this segregation has to be done whether promoters are individual promoters or they are corporate promoters. And then one is to find out applicability of takeover regulations as well. Right. I mean, all these things require, studying these provisions of takeover regulations and other applicable regulations in greater detail.
Yeah. So another thing, what normally one of the things that we also do is, when if you're in a company that is intent to getting listed maybe years time or maybe 18 months down the line, don't think that you need to sit and read ICDR right from the definition section to the last one. No, it won't happen. Start even reading the sections and reading the regulations in a very structured manner. First, talk about this promoter group companies. Third, secondly, you just go and talk about what are the eligibility conditions. Now, when I'm talking about the eligibility conditions, the promoters, you have promoters, and then talk about the promoter general eligibility conditions of the promoter and also of the company. So you just regulation. Don't suddenly get into lock-in and other things. But go stepwise and read the definitions first, because at a later stage, even if we have forgotten or if we are ignorant of certain things, there are other friends, merchant banker friends, to help us and guide us. But at that time, it's for us to go and look into the act and see where more it is a sector, the Section 2, Schedule 2 to the 56 Act that was driving this. It is purely the ICDR regulations that drive the entire process. So more definitions. For example, Mr. Mehta touched on takeover. Okay, now, which is very important, Mr. Mehta. Good that you. I've quoted this: Control versus Subcom Ventures Private Limited SEBI SAT order of this one. Why should it come in an IPO context? So please ensure, because I'll tell you an example. I can't quote the name. In one of the deals, it so happened that the private equity guy was holding 46% and the promoters were holding only 28%. So SEBI very clearly, there was a lot of discussions, and very healthy discussions happened as to whether these guys have to be classified as a promoter or not. But SEBI took a very strict stand that they should be classified as a promoter. But imagine the amount of hardships that this private equity guy would be entitled to when he is classified as a promoter. So that is where the challenge comes. So please identify promoter group companies is very, very, very important, friends. That's why I wanted to chat. Thanks, Mr. Mehta, for touching on the takeover thing. So the control aspect is also you need to right away. So this is where when you talk about control, the articles also plays a very vital role. You can always use the articles route to have a very legal sanctity to so many things. So please read the articles, alter the articles the way it should be before you hit the market. That's the thing which, a couple of minutes, Mr. Mehta, now we can deliberate so that.
Yeah. I think at times you may have to actually recast your articles also. I mean, not only, making an amendment,
Absolutely.
amendments. Yeah.
Absolutely. You need to replace.
Yeah.
Right, actually said, recast, you replace the existing articles. Again, I'm a lot of companies still using the 56, of course. And again, when you do this article, friends, also look into table F and don't reproduce the section. Sab dal do, section mein jo hai dal do. The essential, but don't miss out the essential provisions. Pura but at the same time, don't miss out the essential things. Is what in some companies I would feel that capitalization of profits article is missing. That's why if you look at ICDR, it talks about when a listed company comes out with a bonus issue, it talks about those companies which profits should complete within 15 days, whereas in other case it takes 60 days. So these are some of the things. Don't miss out. Sir, I touched upon preferential offer, buyback, capital reduction, all those things. Please ensure that it is there upfront in the articles. That's why you need to recast, as rightly pointed out by Mr. Mehta. Okay. Anything? I'll take a small 1 minute.
In the meantime, I think I would make a request to the participants who are attending. So if they have any questions, we'll prefer general questions. If there are any, we will be very happy to take them and discuss with the learned speaker.
Okay. Second thing, friends, what I wanted to tell you, because let me put it this way. Understand that it is we who guys have to drive this entire process. Yes, Normally, if you see, there are two sections of this entire process, one or rather three sections, let me put it that way. One, the business sections, where you have the business scenario explained, business models explained, the management discussion analysis explained, all those things are on one hand. The second thing comes the financial aspects of the accounting statements, the tax benefits and other things which our friends and accounts friends will take care of. But third one is what you call as the non-business section. Of course, finance is also non-business, but when you talk about the non-business section, this is where the entire time goes, friends. Okay, so that's the now when you talk about all these things, the backups are also very. Let me tell you a small thing which I think most of us might be knowing. Now, the profile of the directors, when you want to give the profile of the directors, you can say that this guy was, he did it, whatever from Wharton and Cambridge University and other things. He was one of this one, everything's fine. It looks very, very fine. And, the management will be very happy to state all those things, but you should have a proper backing. The most difficult task is go directors and tell them, boss, please, can you give? So some people, and I'll tell you very interesting things is there are retired civil servants. You don't get those, they say we are government servants and government doesn't give us anything at the time of like your corporates. They don't give us any exit, relieving letter or something of that sort. They don't give us. How do you go it? I can't show my pension order to you. So it's a question of, how do you collate that? And if you don't mention it, it's also not correct. Right? Because we have such a, learned people or stalwarts on your board, but, you are not disclosing the real qualification. So ensure that you have this, because this is the most difficult. I'm saying it's a simple loop, but, very embarrassing situation we will end up, and they will come and do you require, I'm such and such a website mein hai, but nothing doing. You need to have that in place, friends. So please talk them, and secondly, even when you go to the civil and watch out investors list or something in the public domain about many of the directors and have a small or merchant banker friends will do all those things, but never mind. When you kickstart simultaneously, if you have sufficient team and thing. Why I'm emphasizing all these things, I can go through the presentations, but it'll be a macro level presentation which I don't want to do. Let's difficulties and what are the things that you and I should be careful of. Okay, now another important thing which I would keep on emphasizing, friends, is Mr. Mehta. I think you would have also seen in many things. The drafting of resolutions, we should not depend on some outsider or some books bringing the form. Books format is just as simple, just to say you do the things, you draft the resolutions the way you want. But if you want, go and look at book after you draft. You don't miss out anything. But don't copy paste. Don't allow. And normally in any kind of a diligence, you have the law firms drafting and there are good, corporate lawyers and the company secretaries within the law firm. Just don't copy paste that. Don't copy paste. That is one thing, Mr. Mehta, and friends, I would really emphasize that. I think drafting skills, we are far better than many other people. Know these sections very clearly, and if you have some amount of command in the language, I think you can have beautiful resolutions drafted.
I completely
please
echo your sentiments, sir. I completely echo them. Drafting of resolutions and actually, what we intend to get it approved by the board or by the shareholders. So that has to be captured very, very, meticulously and very carefully, I must say.
Carefully, correct.
Yeah. So that drafting skill is I think is the asset of any professional like company secretary, and in our curriculum also, as you know, that we have a greater emphasis on this drafting of resolutions and also addressing various issues which relates to IPO procedures and processes.
Correct, absolutely. I would emphasize. So please, friends, that's a great opportunity. Never IPO opportunity, in your lifetime, because it doesn't come quite often. Great exercise, lot of, you let to spend sleepless nights, so never mind. But at the same time, again, I'm telling you, there may be some seniors and there may be some, the freshers or people with some of experience. I will not call them juniors. They were all teammates. Okay, please guide them, please mentor them, please mentor them. If they are doing the job of finding out, digging out all those records, it is for you to guide them intellectually about the applicability of different sections and why we are doing it. I think that is where those team members also will get motivated. I think that is where our entire thing goes. Now, in an IPO, what happens again in terms of processes, you have this 3 stages of documents, right? RHP, second is the RHP, and the third one is the prospectus. You might be wondering why these 3 different stages are, friends, it's mostly, almost the entire kundli of the company. RHP. Only thing you don't mention the issue size or the price and other factors in the DRHP. Okay, but when the RHP, the stage where you also take the SEBI and you just give a final shape, almost a final shape to the process that one has undertaken, and with a price band that can also be an issue, but you have a price band fixed because that's a time when you use the RHP as a marketing material too. So the third one is the prospectus, where finally you arrive at a price which is just make the allotment. Once you finish the allotment, that's at one price that is to come. So please make an analysis of all this. Now, when it comes to DRHP, some of the things that one is, there is a section on entire history, as rightly pointed out by Mr. Mehta, on the milestones or the history. He started with, in fact, incorporation and the registered office. Thanks, Mr. Mehta, because that is where you come and, in fact, very old companies do not have any kind of records for this. That is where we need to. Why I'm saying, if you don't have these records, there is a section called risk factors. You see, invariably in the last maybe 10 years, or at least in the last 2 to 3 years, 5 years, I will say, that lot of emphasis has been given to the corporate. I'm thankful to that. At least now there is a great, importance that is attached to. Yes, it is a basic document that speaks the decisions of the board, right, and the shareholders. So that comes as a great risk factor, friends. Now, when you talk about a risk factor, it is not only the the merchant bankers, but they are also dependent on the lawyers to draft. When they say that you don't have records, then they end up saying that we do not assure you that the company will be able to maintain such kind of. It's with these trends have to go. I mean, kitna bar mai bhi fight karo. These trends have to go at one stage or other. But given a chance, and I would prefer that could be modified, because previously you had risk factors and the management giving its observations on risk factors. So usme kya hota tha, you give a risk factor, but I will counter each and every risk. So that's why that has been taken away. That's been taken away. So now we have only the risk factor getting into that. Secondly, so the risk factor
is more for the professionals, company secretaries to to have this kind of endeavor to have minimum risk factors. I mean, insofar as the general corporate information is concerned.
Correct. Absolutely. Yeah. If you read the risk factors, it starts with some word and, without any full stop, comma, everything, it ends after some 15 or 20 lines minimum. That's okay. So internal and external risk factors. Mehta, I would believe you could just delete, say, investing in equity is subject to market risk, as we say in mutual funds, and finish off.
Yeah, you run the risk of losing your entire investment.
But at the same time, that is the only instrument that creates value, right? That's right. And that's, because each and everything when you put as a risk factor becomes a tedious exercise. One part of it, friends. Second, very important part is the litigations. You go to any company, however old is this company, whether it's a 3-year-old company or a 30-year or a 60-year-old company, litigations is chapter that you will never have 100% perfect litigation MIS with you, and that is where the challenge comes as. So the moment you think of, friends, undergone this more, both from the merchant banker side of how clients as well as from the client as well as working in corporates, both for equity and issues also. So, that's why, the difficulties we were encountering, please, if you could upfront realize and then take a conscious call. And considering the litigations in India, I'll tell you one small incident, friend, about the litigations and how this has taken shape over the years, and how SEBI has also amended the ICDR regulations to some extent on the litigations. Way back, I think it was in 2007, I believe, November 2007 or December, 2007, where in one of the cases, issue opened, and suddenly one fine morning, this guy, one of the, my litigations are not covered in this, in your section. So immediately SEBI said, please give them an opportunity. Whoever has invested on day one should be given an opportunity, and others. And we were asked to, the company and the banker were asked to give an ad saying that this was missed out and this is. But a lot of discussion that took place with the regulators post, paved way for amending the ICDR regulations. And to friends, once you have the MIS on hand, when you have a lot of 100 or 500 litigations, please ensure that the materiality threshold for such kind of litigations. So, SEBI doesn't give that kind of what should be a material. It all depends on the company to company. So materiality threshold is also one of the places where you and I can play a role as to how to determine this materiality threshold. Now, when it comes to disclosures, litigation, secondly, you identify the group companies first, but you need not have to, all the group companies, and you can also have a materiality threshold set for disclosure of the group companies. Now that's where group companies, first it is very slightly difficult find out which are those group companies, and then also to set a materiality threshold that now with this latest amendment of August 13, friends, what SEBI has very nicely said is the issuer need not have to put the entire details of the group companies, but they can link to the website of those group companies where the investor have an access to that information. That's a good thing because otherwise companies, was taking a heavy toll. But at the same time, when this is a good thing that I would feel that had happened. So,
Mr. Mehta? Your slide is, I think, not moving. So
no, I'm not. I'm just. Let me otherwise stop sharing also.
So I thought.
No. I'm not even talking. Okay, so that's what identifiable from is all this, and instruments that could be offered, specified securities. Put the specified securities, friends, where equity, convertibles, and warrant can issue convertible securities also. But if a company is issuing equity, and if you have any convertible securities prior to FPO, that converted into equity. Okay, that is you talk about what is initial public offer and the public issue. And when it comes to offer for sale, many of us, friends, think it's an ICDR driven thing, and the Companies Act doesn't talk about offer for sale. Okay, but friends, let me tell you, Companies Act of 1956 also had, and today 2013 Act, in fact 2013 Act, it's there in two places, for the offer for sale. The offer for sale also has the same process, except that the selling shareholders, they dispose of their shares to the public through the company and get the shares listed. But in terms of comply with everything, and you have the provisions in the Companies Act which is embedded in the Companies Act. Please, friends, 25 and section 28, which talks about sale, and that is how you need to do it. Now, in an offer for in a public issue, a lot of expenditure that is being incurred by the company, because it is raising funds, and whatever the money that is being garnered in it is also a part of the public issue expenses, which from an accounting angle, you can also write it off over a period of 5 years. But when it comes to the selling shareholders, since they are also participating and they are advantage of in getting an exit opportunity through the exit route, the entire expenses have to be, as far as the selling shareholders, whatever is attributable needs to be borne by the selling shareholders, friends. So that is also one of the major things that you need to undertake. Thirdly, even when there is an offer for sale, please finalize the list of selling shareholders who want to participate in this public issue offer, in the public offer. So, because that itself is a separate task of getting those agreements and all those what else? Many documents that are required to be executed. I'm not getting into that, but kickstart the process of approaching the selling shareholders and having at and finalizing the list of such shareholders is a very crucial thing. Friends, but never mind. You need to have that in place. Yes, Mr. Mehta.
There is one question from the audience on this particular issue. If you permit, we can discuss now. Yeah. So the question is that the issuer company makes the pre-IPO placement after filing of DRHP and before filing RHP, whether it has to be included in the net offer to the public.
Okay, let me tell you. See, all these are coined words. Nomenclatures have been given by the so-called investment bankers, and because normally if you look at Indian statute, Mr. Mehta, we copy from the UK Act, but Securities Act thoda alag hai. We copy from the US. Okay, so all these funda are coming from that. What is pre-IPO placement? It's nothing but a preferential offer. For us, it is a preferential allotment, right? Now, before DRA and RHP, if you have the DRHP, should very clearly mention that the company may, you may not really go, but there is that your private equity or somebody will try to come and invest in your company. There is a flip side to it also. Invest. So the DRHP should very clearly mention about this as it will be deducted from the net offer to the public. Okay, so what you want to go and give the public, that gets reduced, because ultimately what happens is all shares are getting listed on the BOSES, and that's the reason it also gets reduced, because you already have somebody coming and putting in money, to that extent.
Otherwise,
reduced.
Going by sheer logic, I feel that whatever is being offered to public, that will be the net offer. I mean, after doing this pre-IPO sale. So
correct. Now, what is that
mentioned very specifically?
Correct. In fact, what is happening is, normally it is only the, what do you call, the preferential allotment of share. I find even some existing shareholders, they want to do a private pre-IPO placement, in the sense they want to transfer it to some other guy, so that's happening. So, so when you pass a resolution, chalo, let me come into that. As a CS, when you pass a resolution for an IPO, please also have a paragraph on pre-IPO placement. Please also include, maybe again, either it can be part of your or keep it a separate resolution, but mention the amount as to what is the maximum that you can. So your explanatory statement also should actually coincide with or give a proper explanation to this. So that is also very important. One more thing, since we are talking about a pre-IPO placement, one more word of caution is that post-listing, post-allotment, a company cannot raise funds for the next 6 months. Yes, you very clearly disclose in the offer document in the DRHP stage itself that if you have an intake, you need not have to do, but if you want to do, please mention it in the DRHP itself. So pre-IPO placement also, please better to take care of, but all the process you need to follow very clearly, friends. So your drafting, that's where I said also you should comprehensively cover different things. One thing which again you and I technically we will question. Offer for sale क्यों मैं mention करो in the resolution? Company has nothing to do except that the company shares are getting listed, but at the same time, whose shares? The company shares are getting listed, and company is a party to that, right? In the sense, the entire DRHP, the entire the process is being done by the company, and only the selling shareholders are signing the document, and of course, the board also has to give a declaration. So that's where the noting you need not have to go to the shareholders for offer for sale, but at least in the board resolution, please do this. Is my request, my suggestion. Yes, Mr. Mehta.
I think there are a couple of more questions which are very fundamental in nature.
Please.
One is that what is the role that a CS plays in selection of merchant banker and the entire IPO also, and what are the points to be taken care during selection of merchant banker?
Okay, good one. What is the selection? So what's the role that you and I can? What is the role that you and I can play? Of course, finally the management has a say in everything. Okay, is that? But I think two things that I would broadly classify. Before that, friends, I would also see there is this. Merchant bankers, if you see any kind of a document DRHP, for example DRHP, there is this merchant bankers track record details have to be mentioned in the DRHP, which is as per the SEBI, not as per the, which is mandated by SEBI. So there is a track record of merchant bankers that comes into being. So you can have a glance at it. It may not give you a full, but that's one base that you can do it. Secondly, when you have what do you call a beauty parade of all the merchant bankers coming and talking to you and do things, couple of things which you need to be aware of apart from the track record is that to what extent this guy regulatorily apart from the two things, regulatory that this guy is as the capability. Second thing is from a marketing point of view, how can the merchant banker can market the issue, whether he is capable, because some merchant bankers, I would tell you friends, there are two things if you are in a merchant banker. One is the execution skills and the second is the marketing skills. I'll come to the third aspect, the marketing skills. So you can choose, that's why an issuer is allowed to have more than one BRLMs, one merchant banker. So first look at the regulatory thing and the marketing. Some people are very good in marketing. I think you should go in with them. Second thing, the network that these guys have. To what extent, these guys will be in a position to offer, the guidance to us. You will say that only when I deal with him, but even in the course of before you select a guy, you will be able to find out to what extent this guy is capable of interpreting the regulatory framework. That is also a very important thing, that the network that he has, how many issues he has handled. That's why please see the track record also, which is very, very vital for all of us to. And the third one, friends, is that Mr. Mehta, I'll also touch on this. Now your entire marketing, why I'm emphasizing it's not only domestic, right? Many companies go and target the other jurisdictions also. Now again, in the jurisdictions, how very clearly, the US is one market, others are other market, and we have the domestic market. So domestic market, the US market, and the rest of the world, you can see. When you do a marketing, when you want to market your issue in USA, please friends, it's a challenge, and you need to be cautious to the core, because there are a lot of restrictions that are that you will have to abide by. So maybe the local councils that we appoint, global, whatever names you call, fancy names you call, the global councils and other people, they will guide you properly. First thing, when you want to market that issue, please request for what you call as publicity guidelines. So they will be. why I'm telling you this, friends, today in the DRHP, in the document, you have the audited financials. Pile it was for 5 years. Now it is only 3 years that you need to give. Now, the Companies Act and ICDR very clearly talks about that an audited accounts which you are disclosing should not be more than more than 6 months old. So always you see, you will have a lot of documents filed on September 30th. 29, 27, 28, 29th and 30th of September, or SEBI will be flooded with a lot of IPO documents because the 6 months period. Okay. Otherwise, you need to get audited, and again for the remaining period, what you call as a stub period, you need to get limited review done, all those. But if you are marketing in USA, your days ends not at the 6th month, that is 180 or 182 days. It ends on the 135th day. In fact, from the 135th day, they don't consider to be an audited accounts. So you need to undergo the process once again. Once again, you need to undergo the process. So I'll tell you one of the challenges that we may not directly face, but we should know that the so-called the auditors, I mean the Indian auditors are fine, but they also have to depend on the foreign counterparts to see whether everything is in place, especially the big firms when they do this kind of an audit. That's what you call as a comfort letters. Now all these things, it's all, friends, it's not regulatorily driven anywhere. But yes, comfort letter comes from SEC, and ICA has issued a guidance note on issue of comfort letters also. To what extent auditors, auditors will give a comfort letter. One of the comfort letter is they are saying anything beyond this date, if it happens, they are not responsible. They are not responsible. That's why, friends, if you're marketing in USA, think 10 times before you say yes to that kind of a deal, because that is one thing. And the third thing which you talked about, Mr. Mehta, on the selection of a merchant banker is also, I would also go with research. To what extent this merchant banking has a research outfit, or a research division capable of coming up factual information about my company, that's why you have the research analyst regulations also in place, right? So you need to see to what extent these research guys are. No, when you do this beauty parade, when you go to the, talk about merchant bankers, when you will all get to know very quickly about who is good in what. It's not something, great. But 3-4 things, the merchant banker track record, you can see in the website of merchant bankers, you can easily get. Second thing is, their regulatory understanding of, especially the ICDR. Maybe Companies Act, yes, they should know, but ICDR to a majority extent. And the third one is, if preferable, see, most of the merchant bankers are, they are also sector specific. Some guys would not take certain things which they are not comfortable with. So whether, a guy may not take, say, for example, a technology industry or maybe a financial services industry if they don't have an expertise. So that's the third thing that you need to see. Fourth is the marketing, which more than we guys, the management would be interested in really knowing that management. And the fifth is the research analyst's ability to come back and say that this is what your research report will look like. Yes, these are the 4-5 major points that I would suggest Mr. Mehta to be conscious of before you select a merchant banker.
One of the most important which you mentioned was the track record of the promoter. What kind of issues he has had previously.
Correct.
Yeah. So
in fact,
please continue, sir.
No. In fact, track record as a track record for the last 3 years, even after, his responsibility doesn't end 4 months after the listing. It goes back and see how the shares have performed. Is there, go ahead, Mr. Mehta.
So one related question is relating to appointment. Can a company appoint merchant banker and the legal advisors to the IPO before approval of shareholder resolution under 62(1)(c) of the Companies Act?
Yeah. Absolutely. See, but there is nothing wrong, friends. So let's see. There are two things. One, the board has to kickstart the process, right? The board actually kickstarts the process of an IPO, right? Now, once board approves, shareholder approval, is there time limit between board and shareholders approval? Absolutely no. Now, how do we do a M&A and acquisition? How do we do an acquisition? It is not that, you go and first get the board approval and then go and get all the approvals and then announce. No, right? And then do your due diligence. No, right? So similarly, just if you can factor that here as well. The board has given you a small approval to go and judge for yourself as to whether you are capable of raising money from the public through issue of equity shares. That's what the board tells you. Now, at that point in time, form a committee. Again, I'm saying from a small committee, you can form an IPO committee or a fundraising committee you form, and they can do all these things. There is absolutely nothing wrong. Once the board kickstarts, you can just go and talk to the merchant bankers, find out, because that is where the real thing comes up. It's not that, because once the shareholders gets an approval, it is basically you are ready for the show. You are ready for the show. Here you need to prepare yourself. So there is nothing wrong in appointing a legal advisor and other thing till that time, you need not have to wait for the shareholders approval. But ensure, friends, you don't do this way that, you have a board approval passed sometime in 2018 and today don't take the shareholders approval for that. Don't do those kind of a thing. I think it should be a reasonable period within which you need to go and take the shareholders approval. Yes, I'm seeing you laughing, smiling and laughing. So
if we take up approval, well in advance, so then that intent of listing get displayed, or you propose to list your shares, and then a whole host of regulations get triggered. Become applicable. So, but in practice, if I may share, the companies usually start this process year in advance or maybe even before that. So they, start scouting for the merchant bankers and the legal advisors. But this appointment actually takes place when they are actually ready to go.
Correct.
Yeah. So this process continues, I think, almost for a year, well before coming with the IPO or FPO. So, but then when they are at a stage, then they can actually go to the shareholders, take their approvals, and then only, this process is triggered.
Correct. Okay. One more thing, when we were talking about, Mr. Mehta, on the Secretarial Records, one of the essential promoter group and other thing. Please, friends, the core area that we also have to concentrate or focus is on the capital built up, right from incorporation till today. I think this is where the entire energy goes. Right. So please, I would urge everybody, when you're doing an IPO, please emphasize on this and please focus on that one. Secondly, depending on the sector to which you belong, is there a special audit that is required to be done? Say an environmental audit, say if you are a NBFC, whether, a typical audit of, that RBI, whether the compliance with the RBI regulations is in place, or if you're an insurance industry, or, take any kind of but if it is a specific to that is also one of the things which we need to initiate. That is where, when you said, Mr. Mehta, about the merchant banker, see, for example, whether he or whether that company, whether that outfit is into financial services, and immediately whether he knows XYZ of these financial services regulations is what one has to know. For example, if he is coming for an NBFC, the first question that he has to ask, or what is the kind of NPA that you have? What is the percentage of NPAs that you have? So all those things will give you a good idea about how good or otherwise is the merchant banker for that assignment. Okay. Now, a couple of things which we need to be very careful of is defining the objects of the issue very carefully, friends. Defining the objects of the issue is also one of the essential things that is required. So when you talk about objects of the issue, why this is crucial is in case you don't have a very clearly defined objects. There is this concept under the SEBI regulation saying that rejection of offer documents, that will kickstart. you go and read those rejection of offer documents, you'll very clearly see that different instances that they have given. Don't, if you have in the past about circular transactions and other stuff, straight away your offer document will get rejected. Once it gets rejected, you can't come out with IPO for the next 2 years, friends. So be mindful of this. This is also very important stage. Now, having defined a very, very clear objects of the issue, you cannot vary the terms and vary the objects of the issue post listing. So what was happening, the background to that was a lot of companies, were using, this kind of a route. You take money for a particular purpose, and at the same time, later on you can use it for some other purpose. Then the entire thing and the investors were left in the lurch, and that's the reason now there is a very clearly, if a company wants to vary the objects of the issue, till that time the money is not utilized for the purposes for which it has been used, then you need to get the shareholders' approval is one fact. But you should also provide an exit mechanism to the shareholders. There is a separate set of regulations under ICDR. It has taken time for ICDR to have this in place, but 2013 Act had a provision for all these things. Section 27 talks about variation of terms. But again, many of friends, if you had even the 56 Act had this very clear provision about not taking the share. I mean, it had indirectly mentioned about the approval of the shareholders that was required to be taken in case of variation in the terms of the contract and documents. So that has been plugged now, and you need to follow a process. Very few companies, 2 or 3 companies to my knowledge, had done this for obvious reasons, that if they could not use the purpose for which it was utilized. So the objects of the issue, the utilization, and what happens is post listing in every along with the financial results, the quarterly results, there is a monitoring agency that is required to be appointed, friends. Any issue of more than 100 crores. This guy monitors the actual utilization, and this report needs to be submitted to the audit committee, and also forms part of along with the results, the amount that has been utilized from the proceeds that you have collected is also required to be stated. So be mindful of that process as well. In terms of, don't think, friends, all these are completely related to our area. Don't think, maybe the utilization is by the, the operations of the business guys, but at the same time, we need to monitor all these things in place. One more, Mr. Mehta, I think I really wanted to emphasize on this fact is when you do the so-called diligence of the secretarial records and other things, many companies in the past would have allotted shares to more than 50 people under the 56 era, or of more than 200 people under the current era. Okay. Now, how do you tackle that? Now, that is a violation. How do you tackle that kind of issue? Now, this is no doubt this will come as a risk factor in your document. But please, SEBI has come out with a circular sometime in December 2015, I believe it has come out with a circular. Please go and refer to the circular as to how do you sort out that kind of issue, where again you need to give back the money to those shareholders. Otherwise, what do you have to do? The entire it's a 2-pager circular that SEBI had come out, and you should please be mindful of this fact. So when you do this, also check whether any violation of section 42 or the erstwhile section 67 subsection 3 has been complied, or there has been a violation. If there is a violation, please take precautionary steps before even you lodge the DRHP. And you should be very clearly telling the bankers about, merchant bankers about this aspect. So that is another area. Section 42 is very, very important that one has to be aware of. Any question in between, Mr. Mehta?
Yeah, we are receiving questions regularly. In this, there are two specific questions which people are asking.
Yeah.
One is that, I mean, we are witnessing, dozens of IPOs recently. Are there any exemptions, or relaxations being given by the regulator? I mean, approving all these IPOs. I mean, we have seen a flurry of IPOs very recently. And
Correct.
second question is, can a loss-making company, come up with an IPO? Are there any exemptions?
Okay. Let me go with the reverse way. Now,
Yeah.
loss-making company, if you look at Zomato, I think let's take that example straight away. It starts with, I am a loss-making company and I will continue to incur loss. I don't know when my break-even point, because the business model is such that, so, in fact, in one of the study, it so came that, they may not even break even after 10 years. But that's a different issue. But can a company with a loss can come out with? So friends, go and refer to Regulation 6.1 and Regulation 6.2. You have two things. A company with a loss also can come out with a public issue, because it all depends on promoters. It all depends on the business model and the industry to which it belongs to. Okay, so 6.2, you will fall under Regulation 6.2. Now, what is the difference between 6.1 and 6.2 is that, you have three different categories of investors in an IPO, right, friends? One is what you call as the QIBs, the qualified institutional buyers, who are the institutional investors. Second thing, you have the retail investors. And the third one is non-institutional investors. These are the three categories of investors in an IPO, right? So in the first category in the first Regulation 6.1, when you are a profitable company and you satisfy those financial parameters that have been mentioned in 6.1, the apportionment of thing, because this is very crucial, apportionment is QAB, is 50%, the retail is 35%, and the NII is 15%. And a QAB, they can't go beyond 50% in the first category. But in the second category, the QIBs have to subscribe to an extent of 75% in the offer. So they have to subscribe to that extent of 75%. If they don't subscribe, the entire issue falls. You can't even underwrite the issue. Okay, that's why, see, the concept of underwriting almost has faded away these days. But there is only one thing in case of a loss-making company. If the 75% should have been subscribed by the QIB, should participate. And that is so a loss-making company can also do an IPO, provided, you fall under 6.2, provided you comply with this one. Okay, coming to the first one, there is a flurry of IPOs that is coming. Are there any great relaxations and other thing? I would not really say that there has been a great relaxation in so many things, but in terms of approving the documents, and it's not even approving in the regulator giving its observations in terms of that, and to a major extent to look at certain things in a very practical scenario is what is giving you a lot of, and this is the time, as I started this session saying that the financial market has a 7-year circle, and this is also one of the areas where the companies can get into raising money through the IPO route. And the latest August 13th, friends, there were two major things. One, I think we touched upon the exemption to disclosure of group companies in the document, at the same time disclosing it in the website. That is one thing. Second thing which it has done is on the promoters lock-in. Now, what the ICDR regulations carried prior to August 13th was that there is this concept of minimum contribution by the promoters contribution of 20%. So post the listing, post the issue, if promoter is holding more than 20%, up to 20% will be locked in. Let me put it this way. Up to, for example, if a promoter is holding, say, 47% post listing, 20% should have been locked for 3 years, and the remaining 27% is locked for a period of a year. Now, apart from the promoters, there would have been some existing shareholders, the private equity guys or other shareholders, friends, who would have invested them, when the company was an unlisted entity. Now, all those existing shareholders have to hold back their shares for a period of a year. Now, the change that has come in here is, in case of the promoter's contribution, anything more than 20%, and for the existing shareholders, that has been reduced from 1 year to 6 months. And in the promoters category, anything about 20%, which up to 20%, which was there for 3 years, has been reduced to 18 months. So this is again a great change that has come into this parlance, but there are advantages, disadvantages of many things, because I invest in a company, the promoter stands there only for 18 months, is not, instead of, in fact, in my view, it should have been much more than 3 years, is what I would feel as a in a personal view, so that investors, when I'm investing money, I come and invest based on this guy who is the promoter, not with an intention that I'm allowing him to sell it off within 18 months. 3 years, okay, slightly, I would not subscribe, but yes, again, it depends on how the vulnerability of the promoters and the industry to which he acts, whether that company is very vulnerable to a takeover, post-listing, all those things has a different connotation. So that's the reason, Mr. Mehta, so to answer both the observations of the audience or the participants.
Please, would you like to share about the 13th August regulation, particularly increasing of this lock-in period, where the money is to be spent for capital expenditure?
So it is very clearly talking about the capex thing, right? It talks about if the objects involve raising of funds for other than capital expenditure for more than 50%. Then this exemption is allowed, because in case of what primarily it talks about is, let me read out. If the object of the issue involves only raising of funds for other than for capital expenditure, maybe English could have been better worded, for other than for capital expenditure for a project for more than 50% of the fresh issue. That means if it is not a capital expenditure, and if it is for some other purpose and for which it is more than 50%, then this relaxation is allowed. Now, the reason could be one more thing. If it is a capital expenditure project, the intention is that the promoter should stay back at least for a period of 3 years, and he should not dispose of his shares, because you do not know how. That's what I was indirectly mentioning about whether this company will be subject to is vulnerable to an acquisition. So that is what Mr. Mehta is talking about. This the new you bifurcate between capital expenditure and other than the capital expenditure, and see whether your objects of the issue, whether it is more than 50% is towards capital or towards capital expenditure or towards the other. If it is towards the other, then this exemption, you can avail the exemption in this case.
These regulations, Ranganathan sir, they have sought to define capital expenditure also, which is an inclusive definition.
Correct.
And this not only covers the plant and machinery, land and building, but this also covers miscellaneous fixed assets, which could be very subjective.
Absolutely.
And this includes civil work as well.
Yes. And that is where, when you need to do this exercise, when you do this capital expense, that's where the you get the expertise of the merchant bankers also to classify the two things. One is the merchant bankers guidance, and also the accounting aspects is what you need to very clearly, on one hand, what we might call as a capital expenditure may not satisfy certain accounting principles also. Because now that with Ind AS, whether everything is falling under to that, because there is another angle also, right? Sometimes you get a lot of tax exemptions when you incur in infrastructure, whether all the combo of all these things have to be seen and then classify it as a capital expenditure is what one has to very clearly see, Mr. Mehta.
Great.
Yeah.
Then there are certain, again, very basic questions.
Yeah.
So I like to discuss some of them. So somebody is asking what is meant by this market lot size, minimum and maximum. So this is very general. Yeah.
Very general. See, if you look at market lot size for a retail public, the 15,000 limit that has been given, that's a maximum that you can invest in a company, right? So that divided by the price will give you the market lot. It's something that don't apply for, otherwise people will apply even for one share. Instead of that, in one way to, I would not say to filter out, but one way to gauge the interest of the investors is also, keep some kind of a lot, because it has to be a lot size rather than, a one share or single share. And that's the reason. Maximum, again, it depends on the price and what is the amount that you are going to invest. So that's a market lot is. But once you get listed, it's all in fungible mode. You can have one share, you can do it. So the market lot which existed during the physical regime has gone. Now only it's in the IPO stage where you have this market lot size of, mostly it is in the multiples of 8 if you really see. It's in the multiples of 8.
Thanks, sir. And another question is grading optional, grading of the IPO. Is it optional?
Yeah. So I'll go back to again to some history. Way back in right from this grading of IPO, I believe it came sometime in late 2006, if my memory serves me right. So grading, why people were considering. So please let's understand the difference between rating. Credit rating is for a debt instrument, friends. Don't get confused. So if I'm doing an IPO of debentures, I'll have to get my debentures rated. Grading is the issue per se. It's not an instrument. No, you're not rating an equity instrument. It's per se grading. And so, a need was felt. A lot of companies were coming out with public issues. And should there be some guy like a rating agency should go and grade this issue? Yes. That was mandated for some time. I think hardly it stayed for 3 to 4 years. But what was again happening is that everybody in the street were getting from 4 and 5. You can't rate a company at 5 out of 5, So, and that's the reason suddenly a need was felt, and that has been not made a mandatory thing. Now it is an optional one to go and get a grading done. It's only an optional thing, Mr. Mehta. Okay.
Great.
Now, and I will just touch upon one thing in between, with your permission, is that, the financial statements that comes into the offer document, friends, it is not a replica of what is being adopted by the shareholders. In an IPO, there is this concept of restated financials, and also you have what you call as pro forma financials. Two different things. Don't get carried away with all these friends, stay or these phrases. It's very simple. Now the word restated, you have an audited accounts which have been adopted by the shareholders. Why do I need to restate? If you look at ICDR, it gives very specific instances as to when I need to restate. For example, when you regroup certain things, or when there is due to the change in accounting policies, or when there is a change in the accounting standards, you have reclassified a particular item to X. And what is the impact of those, events is what is coming by way of a restated financial statements. Otherwise, even nothing changes, because the shareholders have adopted, you would have declared dividends, but only thing to give the correct picture, if it was in the same level, how it would have got reflected is what the restated. Now, pro forma financial is slightly different. A pro forma financial is nothing but whenever there has been some major event in a company. For example, a company has acquired another company, or it has demerged its business, or hived off its division, of one of the divisions in the last 3 years, because 3 years is what you need to give if it was for the last 3 years. What could have been the impact had these events not taken place is what, or if it had taken place, how it would have got reflected. Today, if you talk about acquisition which had happened in the last year, then you need to show if this acquisition happened in the previous 2 years, how it would have been. So you need to give those kind of events and then restate and put the pro forma financials to state how it would have looked like. So this is one point which I just wanted to touch upon, Mr. Mehta. Then,
Thanks, sir.
always, yeah, please. Yeah, Mr. Mehta.
There's one question from an investor's perspective, a
Yeah.
retail investor particularly. So the question is, with so many IPOs coming out, what information a retail investor should look out for? I mean, in a public announcement or a prospectus. I mean, although these are usually, driven by sentiments or recommendation by a friend or some other person, but if some serious investor is there, so what kind of information he should look out?
So there is this concept called abridged prospectus, which comes along with the, what do you call? So instead of looking at this 800-page document, which nobody at the end of the day would have read it thoroughly, okay? So, so I'm saying just look at this abridged prospectus. Couple of things, whether you are familiar with that industry to some extent. Since you use the word serious investor, that means if I'm into financial services or a technocrat, if I'm wanting to invest, I'll understand to some extent about the industry with which it is into. Then maybe to some extent I have to industry, and read the business and to some extent on the business section, but also on the promoter's background. If you look at abridged prospectus, that also talks about the promoter's background. Thirdly, and I would not, because you don't get this track record of merchant bankers and other things. So if I'm a serious investor, two broad things I will look into it is whether I will be comfortable with this kind of a business, whether I can invest in for example, before a serious investor will definitely think to whether before investing in a real estate sector. And another guy, if he is into financial, if he understands NBFCs very nicely, he will try to put money into but he will also gauge whether to what extent the company is and to what extent the company is avoiding what you call as the NPAs and those stuff. I mean, thoda study is also required if I'm a serious investor in that particular thing. So these 2-3 things, litigations, whatever, we are in India, so litigations, we are prone to litigations unless otherwise, it is a litigation which will take away the entire, otherwise the company will not come out with such kind of an IPO. So broadly, if I'm a serious investor, 2-3 facts is what I would definitely see, Mr. Mehta.
Great, sir. Thanks a lot, sir. And one more question concerning the IPO. So question is, what is good time for a startup to go for an IPO? This is, I think, a very interesting question. Yeah.
I think it's
the startup can consider other options as well, like going for SME board or main. I mean, main board may not be a direct option available.
Yes. Yeah.
What do you? Yeah.
Good. It's no doubt good question, but we can keep on debating it for days together. But at the same time, again, when you talk about a startup and other thing, are you falling under the category of biotech and other thing? There is a separate platform called, Innovators Growth Platform under the ICDR, where you can go and see for yourself whether you fall under that, because the listing process is also very simple if you are falling under that category, friends. So first find out whether you are fitting it. If you do not, then there are other, first you need to try out from, I would prefer that you try to do it, wait for some time, let's not have the herd mentality of if some other startups go for IPO, I should also, follow the same path, but wait for some time. You have your strategy formulated very nicely, friends. I think that is one of the startups should very really think of. That is one thing. Second thing is, the ideal time is try to bring in some investor up, before you launch the IPO pad. So try to bring some PE guy and, and let him stay invested in your company for some time, because he not only will he is a financial investor, but he might also get a lot of strategic inputs, and why I'm saying is he will also be interested in getting an exit route sometime later. Okay. And the third one is, of course, if you are SME, you also have that path of SME sector, but SME sector, the way it started and, grown, there is a lull slightly on that front. But I would urge that, the timing you can't assure of any timing. It all depends on the business model that you are into and whether you are a serious player or you just come and do a startup, and then get away and get into some other startups. Don't have that, but you should have a clear vision is what is required. Time will only, tell to what extent, and it will be a, wait and watch is the, to some extent, but lay down the path very clearly. That is what you need, a breathing time. You need some time before you launch the IPO pad, friends. Yes, Mr. Mehta. Hello. 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 Audible, right? So I just thought I'm lost. Okay. So in fact, what you should also do, whenever, there are these different policies once you get listed, there are different policies that are also required to be in place once you are a listed entity. So be mindful of those policies and try to get it approved and by the board well in advance before you do the things. And then, friends, you also have, in case of FPO, almost the process, I will not say to this extent, but more or less, again, you need to prepare all those documents but the process is slightly, because you can also fall under the fast track or in the normal mode depending on the conditions that ICDR has laid down. If you fall under the fast track, I think you can come out with FPO very quickly, but I would prefer, more than FPO, unless otherwise I want to raise money to that magnitude. If I have to raise money to a lesser extent, there are two good routes. One is the preferential allotment route, and the second one is on the QIP thing. So QIP is something which I would always, the most easiest of route, and I'll not say great transparency, but yes, I think lot of what do you call? It's an easy process for the companies to come and raise money by way of a qualified institutional placement. Again, friends, a lot of, if you see those resolutions that are required to be passed, the intimation that you need to give it to the exchanges well in advance, and the pricing at which you should do it. All those things are very clearly defined. But as CS, let us use this opportunity whenever you have, whether it's an IPO or a further issue of shares. I think there is a great potential that you and I can take advantage of it, provided again, let's strengthen our base very clearly as to, what the regulatory requirements are there and how that should be pitched in. And that's how I think plenty of opportunities when you talk about an IPO. It's a long run process, right? In the bargain, I think you and I can learn not only the IPO process, the entire corporate laws is one thing which we can also learn. And again, whenever, one more thing, companies could have employee reservation. There is this thing called employee reservation in an IPO. So when you want to reserve employees, just ensure that when you are giving it to the employees of the foreign subsidiaries, that that there is no prohibition of the employees taking shares of a foreign entity. That restriction you need to just find out from the local guys as to whether that kind of a restriction is also applicable. So that is employee reservation quota is one thing. And when I was talking about book building also, there is this guy called QIB May. Within QIB, an anchor investor who comes one day prior to the opening of the issue and invests in the company. Anchor investor is nothing but one among the QIBs who comes and invests. Even that role of an anchor investor is also getting discussed, and by a discussion paper, it's also being, or a consultative paper that SEBI has floated as to what those things are being monitored. Yes, Mr. Mehta, is there any other? One more thing, thanks. One more.
Sure.
Finally, I think very interesting thing which I forgot to mention. I think you and I are more concerned in that the Companies Act has has been amended from 2018 to say that the concept of registering a prospectus is no more there. It is only a filing that is required. It's only a filing that is required. So we are all of us. But all of us have this concept whether we'll get that approval very quickly and other things. Yes, let me tell you, in case of IPO of NCDs, ROCs don't look into that. I think it's a clean process. Okay. But in case of this RHP and the prospectus today, but in case of RHP where the real approval of ROC was required today also, friends, legally it is only filing. But don't take a chance because at least give that buffer of 1 day. Don't ensure the management that, today filing mein ho jayega. Don't ensure that. Take one buffer day and request that personally, just let's have a dialogue with the ROCs and get it approved so that if not, today during an IPO, you don't sleep. At least you get time to sleep. I will not say sleepness, but at least you get time to sleep. For us, others will be free, but for us, we need to be cautious of this fact is what I'm understanding. So, there are plenty of opportunities, friends. It's all, again, I would emphasize, let's focus on certain very, very fundamental issues, which, don't think that, we as CS, I'll reiterate, Mr. Mehta, is we are the greatest professionals or the best professionals to interpret corporate law. And we should have that confidence is what I would always emphasize. And, just believe in Rahul Dravid let me conclude with that. The sound technique that Rahul Dravid has, Thanks. And Mr. Mehta, I think if you have any other questions.
Very, very aptly said, sir. And I think the role of company secretary and IPO, it has been a kind of, one and the same thing. I mean, people have been thinking that whenever you are coming with an IPO or FPO or any public issue for that matter, the company secretary is invariably there as a core, as a pillar of the entire scheme of the things. So, and that has to be there, and and rightly so, because the company secretary has been trained to do so, and this is a very niche area where we train our members, we train our students also. And one thing I can share, because I've been having experience of both, coming out with an IPO as a company secretary of a company also, and then doing legal due diligences of so many IPO as a legal advisor also. So this IPO process requires entire transformation of the corporate governance structure in the company. Not only that, it requires transformation in the mindset of the promoters also, right?
Correct.
So this transformation has to be visible. I mean, in their conduct, in their approach, in their dealings. It is not that if you were asked to do certain compliances and you do simply but just filing certain documents that compliances are done. These compliances has to be in spirit. I mean, the kind of disclosure, I think what regulator says or what regulation says, these are the minimum benchmarks they have prescribed.
Correct.
So I mean, we should take examples of companies which have gone well beyond those benchmarks, because that is a minimum threshold of a compliance that regulator wants. So I should be giving even more information when I'm going public, raising money from public, or trying to unlock the value of my shares through this process of IPO or follow-on public offerings. And many a times these IPOs are there, I mean, not strictly with the intent of raising money from public, but also some companies, they have taken investment from certain private equity players. They have to offer them some exit route also. So they have to give them an option of this exit, so which is many a times in the form of listing. So that's how they go for IPO. But then whenever, in whatever circumstances they are going for an IPO, so they have to be ready with that kind of mindset that this is going to transform the entire approach, entire working style of the company, and then the perception of the society and industry is going to change. And then regulators also, they are also going to be having very strict stand, because you're raising money from public. So that is also there. So having said that, I think as we reach towards the conclusion of this webinar, so I must place on record my special thanks to you, My special thanks to our Corporate Law and Governance Committee, which conducts this series of webinars, which is headed by a dear friend C.S. Ranjit Pandey, who was past president of the institute as well. And thanks to the the leadership, the president of the institute, Nagendra Rao ji and Devendra Deshpande ji, and all other who are involved in organizing these knowledge-based events, which is the core function of the institution. And at the same time, I'd like to, make an appeal to all the members that if they want that institution should, conduct such webinars on various other topics, we are very open to suggestions, and we'll be welcoming those ideas. Just to share with you, this is a coincidence. The very first webinar which we did under this EEE 2.0 series, so that was on issue of securities only. So now we are doing 16th webinar, so that again comes to issue of security. That shows, that how much interest our members or our fraternity has in this particular important topic. And whenever there is a change in regulation, or there is a what you call another some more milestone is there, so we would love to update our members and equip them with this requisite knowledge. And member who attend this, they get the credit hour also for these 2 hours webinar. So every member gets 1 credit hour, which is mandatory requirement for all the members. So previously we have done webinars on CSR and significant beneficial ownership, appointment of KMPs, and then SEBI LODRs also we have done, corporate borrowings we have done, Niti companies we have taken up, and then we have done webinars on compromises, arrangements, and amalgamations, applications to NCLT, then followed by board meetings, the prohibition of insider tradings, and all. These are all very very relevant topics concerning the TS profession and our members. So members are most welcome to share more suggestions if they have any. And I being your representative in the Central Council, I chair the Expert Advisory Committee of the Institute. If there are any specific issues, you are most welcome to raise those specific issues to the committee. And from our committee, we can give you an opinion reply, although there are certain formalities. But then when you need an institutional opinion, so then you have forum available for any complex issue. Like Ranganathan sir also mentioned, there were certain issues like when you have number of shareholders more than 50 under erstwhile regulations or now 200, then how you handle such kind of situation, right? So that there is non-compliance to some extent, but then how you manage those non-compliances is more critical. And for these issues, members are welcome to raise their queries on a professional basis to the institute. This Expert Advisory Committee will be very happy to handle that. And I'd like to conclude with a very, very hearty vote of thanks to you, Ranganathan sir. You've been, so elaborate, very comprehensive in handling this issue. You dealt all these questions with so much of ease. Just handling all these things extempore. So that is really, really commendable. And we are indeed grateful to you for your time. And I would request my secretariat team to extend this Shaheed Ki Beti certificate to our learned guest speaker today, ESB Ranganathan sir.
Thanks a lot. Thanks a lot, Mr. Mehta, and the institute. I think it's a privilege, right, Mr. Mehta, to be among the our own fraternity people and talk to them on all these issues. And I would again thank everybody, and please have self-belief that we are the best guys in corporate laws. We are not taking, we are not explored that area to our potential is what sometimes I feel for it, but that's what all our friends, we need to understand and develop self-belief, friends. Thanks. Have a great day, and good luck.
Aptly said, sir, because this is very much required. Unless we value ourselves, unless we realize our worth, the world will not, take us beyond our own estimates. This is the fact. So we have to value what we do, and this is actually a real value addition that we as a company secretary do to the corporates, to to the society and to the nation at large. So thank you all the participants, all the viewers for joining this. We are taking this opportunity to sign off now and call it a day. Thanks a lot. Thanks everyone.
Yeah. Thanks friends. Thanks a lot.
Dharmam Chara.